Hi, this is Marisa Portuondo. This is the 8th video in our litigation series, and we're going to discuss mediation. Now, mediation is a wonderful tool that is available in civil cases, and it is where hopefully the two parties can come to an agreement and avoid a trial. Now, what happens at a mediation? I know a lot of people have heard of mediation, but maybe they're not so clear on what exactly it means. So, first of all, it's really important that people understand that everything that happens in mediation is confidential. And the reason for this is that, we want to promote honesty. We want to promote people kind of just, putting all their cards on the table as far as what they're willing to accept, what they're willing to offer in order to make the case go away. So, without giving away everything, the attorneys and the clients, they meet up. They usually go to a neutral location. Sometimes it will be held at the other, at one of the attorney's offices. And there is a mediator. A mediator is, a specially trained professional, usually an attorney, sometimes even a retired judge. And basically, that person should have experience in the field that involves a case. For example, business, personal injury, construction, anything like that. It's really common that mediator will be a former attorney who's practiced in that area. So what happens most frequently is that the parties all get together in one main room, and each attorney takes turns basically, summarizing their theory of the case. So they talk to the mediator and they say, this is our side, this is how we feel about it, this is our position, and if you're the plaintiff, you say, and this is how much money we want. And if you're the defendant, then you go up and you list all the reasons why you think the plaintiff's theory of the case is wrong, and why you think your client's not at fault or not completely at fault. And then the mediator says, all right, let's break out. And what that means is that one party will leave, or both parties will leave and go to smaller rooms. But the point is the parties separate. And so, the plaintiff will go with the plaintiff's attorney into one room, and the defendant will stay in another room with their attorney. The mediator will, usually choose who they want to speak to first. And often it's the defendant, and they will go and they will speak to the defendant and the defendant's attorney, or vice versa, and just come up with, where do you stand? What's the number you have authority, to offer to make this case go away? And then the mediator will go back to the other side and they'll say, all right, they're offering whatever the number is, $10,000 to make this go away. And so then, assuming he goes to the defendant first, then the plaintiff will say, oh no, that's way, way off. We want $100,000, and this is why. And then the mediator will say, okay. They'll go back to the defendant and they'll say, hey, you guys are really far apart. They're at 100,000. You guys are at 10. Are you willing to come up? And this continues sometimes for half an hour, sometimes all day, and it can be a little bit exhausting. The nice part is that the clients do have privacy to discuss everything with their attorney while the mediator is on the other side. Sometimes the mediator will be in the room with us and we'll ask the mediator to leave the room to give us privacy to discuss a specific issue. But as mentioned before, everything is confidential. So what that means is, let's say you're the defendant and you offer $100,000 to make the case go away, and the other side says, nope, we're not taking it. And you end up in trial, or you end up in front of a judge for, a motion for summary judgments, anything like that. They're not allowed to bring up the fact that you offered that money in the past. And again, that is to promote settlement. Okay, we want people to come out here with their biggest number and not be afraid that it's going to be used against them later. So, mediation, when it goes well, is amazing. You walk in, you settle your case, you walk out, and you're done. When it doesn't go well, you have what's called an impasse, and that basically means that the parties cannot come to an agreement, and litigation continues. Now, obviously, the longer litigation goes, usually the more expensive it is for the parties. So everyone is really encouraged to try to come to an agreement at mediation if at all possible. Like I said, it can be a great outcome. And the common thread, I guess the common thing that's said amongst at least civil attorneys is that the sign of a good mediation is that everyone leaves feeling like they kind of got not what they wanted, unfortunately. But the reason for that is that you have to compromise, right? You're not going to walk into a mediation and get every single penny. It's extremely rare that that happens. And it's just like any other argument. If you want it to end, you kind of have to give a little bit. So that's mediation. That's the short version, not so short version. I hope that clarified some things. And tomorrow we will talk about the next step in litigation.